2014 में again your 377 came back. And the reasoning, which makes me very very, what do you know, call it, disappoint, मुझे disappointment इस चीज का है that the court said that trans community forms a minuscule minority. एक इतनी छोटा number है trans community का. So basically I need to understand कि अगर किसी community का number छोटा है तो उनका rape नहीं है, या उनकी sexual activities को आप outrightly कैसे criminal activities बोल देंगे. But somehow the court took this opinion that because the number of transgender community which are being probed because of 377 is very minute, very little number. We call it minuscule minority, and because it's a minuscule minority, we do not want to take away 377. So 377 again came. And finally, in Navtej Singh Johar versus Union of India in 2018, 377 हमारा illegal हुआ, decriminalize हुआ by saying that there are the entire idea of rape or entire idea of criminalizing any sexual activity is based on the jurisprudence of consent. If two consenting adults are involved into a sexual behavior, the third person is no one to call it a natural sexual behavior or an unnatural sexual behavior on the basis of sexuality or sexual orientation of the people who are involved. All law needs to intervene in is क्या कुछ ऐसा हो रहा है जो जबरदस्ती हो रहा है, क्या कुछ ऐसी सेक्सुअल एक्टिविटी हो रही है which is happening forcibly or coercively without any mutual consent of the involved parties. So that was the logic, and the whole rape jurisprudence surrounding around the idea of consent was the idea कि नवतेज सिंह जौहर में finally we got rid of section 377. And then the final judgment, a very celebrated judgment, and worthfully so, is the Nalsa judgment of 2014. So Nalsa judgment was one desperate attempt of trans community to go to the court through Nalsa and ask the court to give them visibility. Okay, they just wanted the court to tell the entire nation that trans community exists. वो एग्जिस्ट करते हैं, प्लीज उनका डेटा कलेक्ट कीजिए सो दैट हमारे पास एक पॉपुलेशन का नंबर हो, सो दैट वी कैन मेक लॉज फॉर देम, सो दैट वी कैन इन्वॉल्व देम इनटू द पॉलिसीज व्हिच आर मेड फॉर द वेलफेयर ऑफ द सोसाइटी. तो वो विजिबिलिटी ग्रांट कीजिए. एंड दिस इज द मोस्ट रिमार्केबल जजमेंट एंड अ very progressive judgment when it comes to transgender community. This is where the court said that kindly data collect कीजिए, इनको इनके TG कार्ड बनवाइए and start calling them third gender so that people can think that there is another gender which exists and there is life beyond male and female. And that is, after this particular judgment, you might see बहुत सारे ऐसे government forms हैं जहाँ पे एक third gender का column हमने add किया है, जहाँ पे you can actually identify yourself as the third gender. So these are 4 remarkable judgments जिसके बाद हमारे transgender community के लिए we created visibility. We created a notion that this community exists, and as a society we all are under this responsibility to pull them to the mainstream society and promote their individuality and use their potential for the development of the country, specifically when we talk about Viksit Bharat. Then the laws specifically for transgender, Supreme Court said कि आप बनाइए एक ऐसा law which technically and specifically talks about the transgenders. And as I was telling you, data collect कीजिए so that developmental schemes can be made according to the data collected, not for males and females only, but for the transgender community also. Then, if we talk about the legal framework which is present in today's scenario in India for the trans people, one, we have UDHR, Universal Declaration of Human Rights. Then we have CEDAW, which is a Convention for Elimination of All Kinds of Discrimination Against Women. Then we have Yogyakarta Principles, and then 2017 May we had Yogyakarta Principles plus 10, which specifically talks about gender inclusivity. LGBT community को specifically यहाँ पर इन्होंने रख के ध्यान में कुछ principles बनाए हैं. Then we have Constitution of India. Definitely the whole soul of Constitution of India is social justice and equality. And then we have a specific law which was enacted after Nalsa judgment, Transgender Persons Protection of the Rights Act of 2019. Just a second. So let me take you through these legal frameworks very quickly. UDHR में एक आर्टिकल 16 है which talks about finding the family and marriage. So यहाँ पे ये बोला गया है कि आप किसी भी race, nationality, religion को belong करते हो, you have an equal right to found a family, which we are keeping our trans community deprived of. So definitely family abandon कर देती है trans community people को, and nobody else. There is no other mechanism. शादियां हम रजिस्टर नहीं कर रहे, सेम सेक्स मैरिज को हम अप्रूव नहीं कर रहे, अडॉप्शन हम अलाउ नहीं कर रहे. So definitely we are in a way violating what Article 60. Marriage shall be entered into only with the free and full consent of the intending spouses. So that is something which is still debatable, that if not marriage, probably we can talk about companionship. We can talk about creating a family. If you don't want to touch the institute of marriage, let's just talk about companionship. Let's legalize and derive a mechanism wherein a family kind of structure can be created, a support system can be created for trans community. Then we have CEDAW. There are certain principles in CEDAW which are very important here. Number one, gender identity and expression. So definitely CEDAW focuses upon individuals and how they want to identify themselves. Everybody has a freedom to identify its own identity, whether it is gender identity or the sexual expressions. We all have the freedom to do so. Intersectionality, again, is something which must be part of gender equality. And state obligations hai under CEDAW कि वो ratify करे CEDAW को और encourage करे अपनी domestic territory में to eliminate the discrimination and also address the needs and rights of transgender individuals also. So basically, the entire focus of CEDAW is elimination of discrimination and all forms of discrimination. Although the convention is designed specifically for women, but it definitely propounds certain principles which talk about equality and elimination of all forms of discrimination. And then there are certain general recommendations talking about protection and elimination of women from discrimination. Then we have, as I was telling you, Yogyakarta Principle plus 10 hai hamare. Yogyakarta Principles were propounded in 2006, and then in 2017, plus 10 Yogyakarta Principle were propounded, and they were talking about marginalized groups, specifically LGBTQ community, including the transgender individuals. And there are certain important points which are significant here. Number one, they recognize the gender identity, pounds for non-discrimination, access to healthcare, protection from the violence, and intersectionality. Then we all know Constitution of India preamble अपने आप ही सबसे पहले mandate एक create करता है कि हमको equality attain करनी है, social justice attain करना है, freedom and dignified life for all is something for which Constitution of India stands for. Then all the transgender persons
ये
are
कैसे करें, कुछ
entitled to
कुछ
enjoy
दीजिए
as
आइडिया
much of the
कैसे करें
protection of law as anybody else would,
लाइव का।
because we have Article 14, we have Article 15 and 16, which talks about prohibition of all sort of discrimination and gender biases, whether it is in employment, whether it is in policy making, or whether it is in any other form of civil interactions. Then this is the main legislation which I was talking about. So Transgender Act,
मैं
जिसको
बंद
हम
कर देता हूँ,
trans
ये भी
TPA
बंद कर
बोलते
दीजिए।
हैं basically, this is a 7. So 377 हुआ decriminalize हुआ by saying that there are the entire